Alrighty. So let's start the session here. I think we're about half a minute away, so we'll do that here in just a second. Alrighty. Well, hello. It is that time again for Life Copilot's expert panel. I am so excited today. We have Sarah McClammer here with you. She is with, well, I'll let you explain all that kind of stuff as what you do. She is a guardianship attorney. I just now found out tonight that is now her full scope of what she's doing as far as law is with the guardianships. I'll let her explain all that. But I think that a lot of people don't really realize what all that is and what that means and why it's important to do so. I do know that I've been in the guardian role appointed, with my uncle. And I have read that it is the number one way of getting sued is to be this layperson doing that. So if you're going to get sued in family, I think that happens a lot. So Sarah can avoid some of that for you. But Sarah, would you go ahead and introduce yourself and what you do, and we'll go from there.
Sure. Well, I'm going to share my presentation here. How does that look, Jim?
Looks
You
good.
see that? All right. So my name's Sara McClammer. I work for a company called Scout Advocacy, and we are a professional fiduciary company. So we serve as guardian, power of attorney, trustee, personal representative, healthcare representative for mostly older adults, but some younger adults as well. And so we started this company back in Scout Advocacy was 2020. But Ken and I had been doing guardianship work since 2015. And so we just saw a gap in the market where we were being asked to serve as guardian all of the time, but no one else. And to this day, we aren't aware of any other company in central Indiana or really the state of Indiana that combines legal expertise and healthcare expertise. So Jane Malkoff is a nurse practitioner. She has been a geriatric care manager for over 20 years. And the combination of those two skill sets is really unique. And we're really proud of the work that we can do for our clients. So here's just again our services. We provide comprehensive fiduciary services, both healthcare and financial services. But today we're going to talk just about guardianships. So we're going to talk about what they are, when they're needed, when they don't work. Jim, I've never heard that statistic before that about suing a guardian. It's actually really hard to sue a guardian because there are lots of rules in place. As long as you're acting reasonably, as long as you're acting with due care, you are pretty protected under the law when it comes to decision making. Now, could there be room for abuse? Absolutely. We'll talk a little bit about that. But generally speaking, being a guardian is pretty safe, especially when you're doing it for your family, as long as you're not going to take all their money. So let's talk about what guardianship is. I think people don't always know exactly what that means. So a guardian is a court-appointed fiduciary. So a lot of people are more familiar with a general durable power of attorney, a healthcare representative. Both of those are documents that you sign naming someone else to be your guardian. A guardianship occurs when a person becomes incapacitated and can no longer sign a power of attorney or a healthcare representative document. So then we go through a court process where a judge names somebody to be your essentially power of attorney and healthcare representative, but we call it a guardianship. And so it can be very expensive. Anytime you're going to court, hiring an attorney, it can be a very expensive process. But there are also a lot of pros that go into a guardianship, and we'll talk a lot about those tonight and why you might need or want a guardianship. One of those is that there is court oversight, at least in theory. Courts are very overworked. They don't always have time to fully oversee a guardian's work, but there is that level of oversight. You have to file accountings with the court. You have to give a report on how the person is doing, where they are living. And so that is different than a power of attorney or healthcare representative document where there's no oversight of that. So generally, so that's a pro. A con is that the individual under guardianship generally retains no decision-making authority for themselves. So once you are under guardianship, you can no longer open a bank account, sign a contract, enter into any kind of legally binding agreement. Your guardian has to do that for you. And so it is it is something you shouldn't go into lightly. Now, most of the people I think that are going to be watching this would be thinking about this for a loved one, a family member. You're never going to go seek a guardianship attorney for yourself. So that's sort of the context that I'll be talking about tonight. When you think, a family member needs a guardian. So it can be out of necessity that individual needs help to manage their affairs. It could be to protect the individual from financial or health exploitation to get them out of a bad situation. And it's often seen as a last resort. And in fact, the court has a duty to investigate whether there are other options to guardianship before granting the guardianship. So it's not something that we take lightly. When I was an attorney representing families who wanted to become guardian, we talk about that all the time. Is there any other way that we could do this? Often there wasn't, sometimes there was. And so it's, for lack of a better words, it's a big deal. It is not a short-term transaction. A guardianship lasts as long as that person is incapacitated or alive. In a lot of cases, a person is not going to regain capacity. And so it doesn't end until their death. So that could be years or decades. So let's talk about what a guardian would do for a person. So if you think a family member needs a guardian and you want to become that guardian for them, these are some of the things that you do. These are the things that we do as guardian for our clients on a daily basis. We're gathering their mail, we're paying their daily bills, we're filing taxes, we're managing all their investment accounts, we're receiving their income, making sure their house is secure or their personal property like jewelry is well taken care of. All of those things, all the financial things you do for yourself, you are doing that for another person. Same thing with healthcare, management and coordination of all of a person's healthcare. So making sure they're going to appointments, seeing the right kind of doctors, follow-ups, testing, medications, all of that, where they should live, whether they're in the right living environment, making sure they have everything in their living environment to live their best life. So the requirements for a guardianship are that a person is incapacitated and they're in need of a guardian. And so incapacity is a legal determination, usually based on medical evidence. So that means a doctor fills out in this 2-page assessment form. And the questions are, can this person manage their own finances? Can they manage their own healthcare? Yes or no? Why or why not? And that's generally the extent of the medical information the court uses to determine whether or not the person is incapacitated. Now, are they in need of a guardian? And we'll talk about this more as we go, but a guardianship isn't a magic wand that fixes all problems. It can fix a lot of problems, but not all problems, as we'll see. So let's talk about Betty. This is sort of a kind of I don't want to say routine guardianship, but this is what we see a lot. So Betty has been diagnosed with dementia. by the time her family realizes she needs help, it's too late for Betty to sign her own estate planning documents, like that power of attorney and healthcare representative form we talked about earlier, where she could name her chosen person to act on her behalf. It's too late. Once you can no longer read and understand those documents, you can no longer sign them. And so that's not an option anymore. So she has a lot of assets to manage, and the only option might be a guardianship. She didn't have any assets. It might be a little easier because a family member could manage her health care. But anytime there are assets that are individually owned, no one else can manage them, even a spouse, if they're not on the account, without a guardianship if it's too late for a power of attorney. And Jim, please, if any questions
Well, one
arise.
of the things I was going to ask you on that, the I was reading about Betty here, and we're carrying transitions. We don't get involved in the finances per se, but we help people like clean up estates. We help people pack and
Mhm.
move. We help people downsize. We do all, so we're involved in much of this, information. Okay.
Yeah.
Um, and it's not uncommon that we'll be working with someone who really doesn't have family to lean into. They don't, for whatever reason, they never had kids, or there's estrangements, or, there's all kinds of different things that come about. And I've had several different people that have asked me that are not at the stage that they need any care or help at this point, but they have a fear. What do I do if something happens to me, because they don't have anyone to lean into?
Mm.
Is there an opportunity for someone like that to create a relationship that there's a trigger point?
Yeah. Yeah, so absolutely. And that's why we created Scout. There are other companies similar to ours as well, because there is no sort of public system that, that can serve people like that. It's all private. And so you have to have your own people and name somebody. So if you find a good estate planning attorney, they can give you options. They can say, I know this person, depending on your level of assets. A financial person could be a bank. It could be another trusted resource. You can create. So I don't want anyone to not go get an estate plan because they don't have anyone. If you find a good estate planning attorney, they will have options for you. They will be able to recommend. And more, I think those options are becoming really viable and there's becoming more and more options. So Scout is not the only company like us in town that can serve in these roles. There are other options as well. So go
Well,
talk to
another
a good
question I
estate.
have from one of your previous slides, you were talking about the role of the guardian is, of course, financial. That makes all the sense in the world. But also different financial or different medical and health. You guys are uniquely positioned with Jane. I mean, Jane's been doing that geriatric care management and has had a home care business for a long time before she merged in with you guys. So I see that as a pretty easy thing to do. But how do other guardianships handle that if they're not medically trained or prepared for that?
Yeah, I think it's just like any other, like any parent who's dealing with a kid's, you know, something medically complex, or any adult person whose parent goes through the medical system. It can be difficult. It's not impossible. So you just have to, and I think I have slides coming up where I kind of talk about what skills that person needs. They need to be able to ask informed questions. They need to be logical and analytical in taking in information and making a good informed decision. And it is a complex healthcare system that we live in. It's not an easy system to navigate, but it's definitely not impossible if you're diligent and work hard. Like we do offer healthcare consulting, and I know there are other healthcare consultants or geriatric care managers out there that walk alongside family members to support them through that process. So that's an option too. without naming Scout Advocacy as, a healthcare representative or guardian of the person, you can just use us as a resource to call upon when needed. Or, we even take some of our clients to doctor's appointments, check on them on a regular basis and things like that. But it's definitely not impossible to do. I wish there was a great resource where you could like get trained and learn and do this work, but unfortunately there's not. Maybe someday there will be. But I think it's a lot of trial and error and, being able to ask the right questions and look for the right resources for sure.
Well, I was going to say that I'll let you go with your thing, but I was going to say that there's questions that come up as we're going through. So,
Yeah, absolutely. Anytime, please. So, can an estate plan prevent a guardianship? And we've talked a little bit about this, but let's dig into that a little bit more. My answer, great attorney answer, is sometimes. So let's talk a little bit about this. So we've already talked about a power of attorney and a healthcare advance directive. So those are the two main documents you need during your life to ensure somebody else is available to take care of you. So again, we talked about earlier, if you don't have that person in your mind already, find a good estate planning attorney. They will be able to walk you through this process. But if you do, a lot of people go to an estate planning attorney because they want to know where their assets are going to go after death. They want to know that their nest egg is going to their kids or their choice of charities and the house, and when the house gets cleaned out, they want to know that the china set goes here and all of that. And we always ask clients to think about what happens between now and dead. Those are the most important years of your life, and you're not giving enough thought to who's going to be taking care of you, not just your assets. Let's talk about you. And so that's where the power of attorney and healthcare advance directives come in. They're very, very important. They don't make any situation exempt from guardianship. And we'll talk about some examples that we've had in our practice where they're just not quite enough. But I see over and over and over, we get guardianships or we become power of attorney because the client didn't put enough thought. They didn't have a good estate planning attorney that could really walk them through this process and help them think about who to name in these roles. And so let's give a couple examples. So first we have Bill and Connie. So they have a blended family. They each brought their own children into this marriage, which was a second marriage for both of them. Their children do not get along. So they hired an excellent estate planning attorney and they decided to name their own respective children as their agent. So Bill named his children, Connie named her children. But the children still can't get along. They fight and argue, and Bill and Connie's well-being suffers. So Bill and Connie want to live together in an assisted living facility as husband and wife, but the children, bicker. They can't decide where they should live. They can't decide what kind of room they should have. Everything is a fight. They both have dementia. They no longer have capacity to sign new documents. However, things cannot remain as they are. So this is based on a real example that we've had in our practice. This is obviously not Bill and Connie on the screen. It's not their real names, but this is a real situation. And what happened was the kids ended up having to go to court and get guardianship. They named us as guardian, and we could kind of be that neutral third party that made decisions without emotion, without, trying to make the other side angry. And we were able to really help Bill and Connie navigate their last few years of life. I don't want to say the arguments between the children went away, but I do think they learned to sort of just be with each other. And so this is an example of where they had an estate plan, and I don't know how well they thought through who they're going to name as their agents. But if it was my clients, when I used to practice estate planning, I would have pointed out that naming, Bill naming your kids and Connie naming your kids who don't get along with each other is maybe not the best course of action, because you want to live together and you want to stay together and your assets are commingled. And that just sounds like a recipe for a disaster, which it was. And so that's one example where I think we need to think through a little bit better about how we name our agents in these documents. Let's talk about Stephanie. So Stephanie's in her late 70s. Her and her husband have been going to the same church for years and years and have a steady donation history. They gave about like $1,000 a month by check, like clockwork. So her and her husband did not have children, but they have friends and family nearby who they name as their agents. All of a sudden, their health starts to decline, and then Stephanie's donation history to the church all of a sudden 10 times what it used to be. So if her donations were $1,000 in the past, they're now $10,000 a month. She signed her house over to the church, made the church the main beneficiary of her very large estate, and like even getting ready to name like the church pastor as her power of attorney. So the friends are no longer able to manage these issues. It's too much. They are, they had no idea how large this estate was. They don't have the skills to kind of roll back or deal with this predatory church. And Stephanie can no longer sign new estate planning documents. So the only option was to get guardianship. And just, normally in a situation, I would say, this is a situation where they did the best they could. They didn't have family to name. They tried to name their good friends, maybe like a niece or a nephew. The situation sort of got out of control with this church getting involved, and we had to get involved to kind of roll things back. I do think this is an issue where the size of this estate really required somebody with expertise in managing an estate of this size. We're talking about millions and millions of dollars. And so naming a layperson who has no idea the extent of your estate, they're very private. They don't spend any of their money. They don't like to spend money. So nobody knew how big this actually was. Clearly, the church figured it out at some point. But again, you got to know the situation. I'm guessing Stephanie and her husband didn't even tell their estate planning attorney the full extent of their assets because that's how private they were. And so, you really need to be careful and you need to know your own situation. And I think a good lesson to be open and honest with your estate planning attorney to share those details. And I think it makes a big difference in how their plan could have been different. So let's talk about Dennis. He's a widowed man in his early 80s, two children, one is estranged. He named one of his adult children as his power of attorney and healthcare representative. That child moved Dennis into their home, then spent Dennis's money to completely renovate the home. Full addition to the house where Dennis lives, a new kitchen, and a swimming pool, all with Dennis's money. Dennis's doctor is concerned because Dennis has missed several appointments and not refilled his medications. And so there could be a world where this was fine. Dennis wanted this. Maybe they got him a different doctor, and that's why that doctor hadn't seen him. But in this situation, it was for nefarious reasons. So, of course, no one wants to think that their kids are going to steal from them. And I don't even know, I think steal is the wrong word here, but maybe just like misuse funds. The son was writing checks from Dennis's checkbook to himself, to contractors. Should Dennis be paying for the full extent of their house renovation? Maybe Dennis wanted to. But these are situations we see all the time. Now, I don't want to tell you that every situation ends like this. I don't want everyone watching to be like, oh my gosh, like I can't name anyone. I don't trust anyone to be my power of attorney or healthcare representative. And that's not really the point here. The point is to be really thoughtful about who and how you name people, and really watch out for warning signs. I think this is our last example. So we have Sam. Sam's a widower. He has two adult children, and he named them as his agents 10 years ago. They were both young, married, no children, very capable professionals. And he has a great relationship with both of them. He's named one and the other as his agents in his documents. Fast forward 10 years, Sam's medical conditions, has dementia. He's getting worse very quickly, and his needs are very high. The nursing home is calling almost daily, and he has a large estate to manage, and things are just getting really complex. Sam's two children, while they love their father, they have families of their own and they're very busy and very stressed out by this whole situation. They just want to go spend time with Sam, visit him without having to manage all these things, without the nursing home calling in the middle of the night multiple times a day. And so they really just need to get out of this situation. And so this is, I think, a good example of updating your estate plan, really thinking through on a very regular basis, does this plan still make sense for my current circumstances? When Sam made this plan 10 years ago, it was great. His sons were young and capable and professional, and back then they probably would have had no problem. But now they have young kids and families of their own, and it's just a lot. And Sam's medical needs may be escalated to a point they weren't anticipating. So again, things change. This isn't a situation where anything bad was happening, just the sons needed to get out from under this burden. And so again, circumstances change, things change. You can always and should always make adjustments to your estate plan. I used to tell my, clients as they age, it's probably a 2 to 3 year reconsideration, maybe sometimes more. Every time there's a big shift in your health, in how your agents are doing, you really got to think about that. One thing too that I'm trying to get estate planning attorneys to think about. So one thing in all of these circumstances had in common was their estate planning documents named maybe one or two people, and that was it. And once a person loses capacity, there's nothing you can do to add or change those documents. So one thing that savvy estate planners are starting to do is adding in an alternative for a professional fiduciary. Even going as far to name some of the companies that do this kind of work: Scout Advocacy, Arrow Fiduciary Services, Mary Heller, some of these people in town that do this professional fiduciary work, either naming them, a professional fiduciary such as, and this just could allow us to take over as power of attorney without going through the guardianship process.
What happens in that circumstance? Let's say they're really planning out well, and they pick, their son that's the trustworthy, phenomenal, walks on water kid, right?
Yep.
And they become incapacitated, and that kid is in a car wreck and is gone. If they don't have, if they have, say Scout or whoever is capable of coming in, if they have that, do they just does someone just contact that person and set it up, or if it's not on there, what do they do?
Yeah. Yeah. So if we're named as like an alternate, or like, often we're named after like a spouse, maybe like a spouse, child, us, or a spouse, then us. We have a check-in system where we are checking in with our clients we really do it some clients are every 6 months, some clients are every 5 years. It just depends on the circumstances. And then we always ask the clients to check in with us if anything big changes, if anyone ahead of us in line to be power of attorney can no longer do it, dies. We want to know that if we move up in that line of succession. And so in that car accident case, if, let's say Sam named his kid, dies in a car accident, we're named after his kid, we can just take over if needed, or we're in line to when Sam needs help. If we're not named, and the son is the only person named in the documents, then you're looking at a guardianship situation if they need help down the line.
What Yeah, because I'm saying I see those kind of things happen,
Yeah.
and I remember when I was I was a guardian according to the VA because I had to have that for the VA aid and
Hmm.
attendance,
Yep.
but I was a trustee on the trust. But when we were setting it up, one of the things, my uncle's passed now, so I can kind of tell you something, but when we were setting it up, one of my fears was because my attorney, who's very good at the elder law attorney, so there was different ways we could do this, but one of the, to get him to where he'd qualify for the, for the different things. He said we could put my wife on his bank account and myself on his bank account, and then the way they would look at it is they'd split it three ways, and he would qualify into that category. We ended up going with the irrevocable trust because I was on the road a lot, and I'm like, if I'm in a car wreck, I don't want to be sued, and they attach that.
Mm-hmm. Mm-hmm. Yes.
But I mean, it worked out well, but it was just, but that's we ended up going with the irrevocable trust for that particular one, but
Yes. And, early in my career, I had a case where we had a similar circumstance where mom transferred all of her assets to daughter to qualify for VA benefits. And then when mom asked daughter, like, hey, can I have some of my money back for XYZ? Daughter refused. She said, no, it's my money. You gifted it to me. It's mine. I don't have to give it back. And so ever since that circumstance, I've never, ever recommended that sort of arrangement where it is a joint bank account, because a joint bank account is uh, uh, you know you can go to the bank and withdraw it all.
yeah.
One person can, or if they die, yeah, somebody dies, yeah. So yeah, I like that, the trust idea a lot. I think that's
Well,
a
I felt it was another layer of protection from a lawsuit or from whatever else it could come
That
along.
too, absolutely. Yes. If you're named on that bank account, it's an asset that a creditor could absolutely go after. Definitely. And
Yeah,
in the case I had, that daughter was married and got divorced, and all of the sudden that asset becomes part of the divorce,
yeah.
and then half of it's gone. So yeah, you never know what kind of thing like that is going to happen.
Now, is all of your relationships? I may be getting ahead of things, but
Okay.
are you guys all private pay, or is there any?
Yes.
Okay,
Yeah. Yes, so we have a pre-screening process to determine that clients have sufficient assets to pay for our services, because we all are, yes, all we have is private pay. And so we don't take, clients have to have a certain level of assets for us to come on board, because we have to get paid, unfortunately.
I understand that. I know Ken was doing something, on a different basis at one time. That's
Yes.
why I said no.
He still has that. The Center for At-Risk Elders, or CARE, do serve people that don't have funds. They only serve people that they get referred through certain hospital chains. They have relationships with these hospital chains, and that's how they have money. And so, yes, they do that. It's very limited. You have to be in the hospital to get that referral.
Okay.
Yes. So, all my previous examples are just talking about what happens when maybe you don't think through who you're going to name as your attorney in fact and healthcare representative, which could lead to guardianship. So, one of the things we talk about at Scout, and we really like to talk about with our clients, with our estate planning attorneys. So, we don't do any estate plans. All of that is done by outside estate planning attorneys. Is to get clients to think about who should they name in these roles to manage their finances and healthcare. So who do they trust? Who will be reasonably available? The law requires a healthcare representative to be reasonably available, whatever that means, to manage healthcare. So you need to be on call if an emergency comes up. You need to be able to, figure out what nursing home they're going to live in, all these other things that can be hyper local. That's very hard to do from afar. Similarly, do they have time to respond in a crisis? Do they, and we talked about this earlier, do they have the skills necessary to talk with medical providers or financial advisors? All of these things they need to do this job well. And I'm sure, as you know, Jim, it's not an easy job. Even the most, straightforward assets, healthcare, there can be a situation that gets a little hairy and rushed, and you have to make big decisions in a short amount of time. And it can be very difficult. So here are just some questions that we tell our clients to consider. Why did you pick this person? If the only reason is because they're my oldest child and they're going to get mad if I don't, I used to hear that all the time as an estate planning attorney. I don't think that's a good enough reason. You got to think about where they live. If they work full time, do they have family obligations? How do they handle pressure? Are they able to learn new things quickly? Are they able to think critically in high pressure situations? Can they manage multiple things at once? Can they manage their own life and your life? Are they well organized? Have you discussed it with them? Are they truly willing to do it? Do they understand what they're agreeing to? I think that's the big one. Of course, an adult child, if they like their parents at all, are going to say, yes, mom, of course, I'll do that for you. But do they really understand when it comes down to it, what that is going to look like? Because that can be, as we talked about, it can be a lot.
Overwhelming.
Overwhelming. So that's a little bit about, what a guardianship is, when it's required, even in situations where you have an estate plan, it doesn't completely take away the issue of guardianship. And I just want to talk a little bit about when a guardianship doesn't work, because I used to get these calls all the time. As a guardianship attorney, we get them all the time at Scout. And so let's talk a little bit about that. So we call them failed guardianships. Sometimes we have been in circumstances where we've been named guardian and we're not able to accomplish anything and we failed guardianship. It's just not an appropriate guardianship. So it's not appropriate in every circumstance. Like I said earlier, it is not a magic wand. It's not going to fix all problems. So, first example, a person has capacity, but they're not agreeing with your plan of care. Got this call all the time. My mom should be in assisted living. She's still living at home. I don't think she should be there. I want to get guardianship so I can move her into an assisted living. But if mom still has capacity, if she is not, doesn't meet that definition of not being able to handle her own affairs, if a doctor's not going to sign off that she, can't do that, a guardianship is not appropriate. So disagreeing with a plan of care, sometimes you do have to wait until things become, and this is very hard for family. I've been there with my grandparents having to advise my parents to sometimes you have to wait for a crisis. Sometimes you have to wait for things to get a little bit worse before you're able to kind of move and do things. And we have to remember people, have their own, they have the ability to make poor decisions. Poor decision making is not incapacity, unfortunately. We might all be under guardianship if that was the case. So we do have to sort of really pick and choose what cases or and what circumstances make the most sense for guardianship. Even a diagnosis of dementia, Alzheimer's, Parkinson's, probably even ALS, things that we know people are not going to recover from. A diagnosis does not equal incapacity. It could absolutely start the conversation about what kind of estate plan and things that you might need. We had a client who got diagnosed with Parkinson's pretty early. She had no estate plan in place, and she worked diligently to get that plan in place. And Jane worked with her for, I want to say 15 years towards the end of her life, because she had put that estate plan in place after her diagnosis, but before she was incapacitated. So a diagnosis is definitely a road sign, but it's not the end of the line. It does not mean a guardianship is needed or required. But it can mean that we need to do some serious thinking about those next steps. So intermittent capacity is one of the hardest ones. So we're looking at mental health illness, addiction, things like that, where capacity could wax and wane, where you have, situations where the person is hospitalized and for an acute amount of time and then they're better. So schizophrenia is a good example of this where, it really goes up and down. And while they're in that acute state, or maybe when they have a relapse and they're in addiction and are having trouble, Those aren't always great circumstances for guardianship. The unfortunate reality is a rehab center, a mental health treatment center is not going to take a person against their will, even if they have a guardian, even if it is clear they are addicted, they cannot get out of it without help. If they're not going to voluntarily check in, they're not taking them. So a guardianship is not a good solution to get somebody into treatment or rehab. Unfortunately, that's just not how the system works. Similarly, if a person, we see this a lot with younger, able-bodied individuals who maybe have some sort of incapacity, a guardianship won't make them stay put. It won't make them live at a facility or a group home. If they want to leave, they're leaving. I know CARE had a person who just hopped on a bus and traveled across the country and never came back. And you can't have a guardianship over a person that you can't physically contain. So there are some circumstances where a guardianship is just not the right answer. You're not going to waive your guardianship paperwork in front of somebody, with schizophrenia and say, this means that you have to listen to me. This means you have to get treatment. Unfortunately, it doesn't work like that. So guardianship is not appropriate in all circumstances. Again, at the beginning, when we talked about Betty, I would say those are the most common circumstances where somebody just has like slowly declined and not gotten their estate plan in order. And all of a sudden they need a guardianship. And that's where, most of the guardianship stuff falls. So that's the end of my prepared presentation. But Jim, we have time if you have any more questions.
Well, I know myself. I had a circumstance that happened. I think it was last summer. Okay, I have a tendency to all my stuff kind of runs together this one long string.
Yeah.
But I think it was last summer. We were working with a client who I will guarantee you from working with her had dementia, but there was undiagnosed. Okay. Um, she had burnt all the bridges in her family. Okay, so she was very much on her own.
Mm-hmm.
She had how we got involved is she had reached out to a long lost cousin she was close to when they were kids to ask for help, and he had stepped up. He and his whole family had stepped up to do so, but they were in another state. He was 84 years old, and he had stage 4 cancer himself.
Oh,
Okay,
wow.
so
Yeah.
he obviously didn't know the ropes here in Indianapolis. He really couldn't travel. Um, so his daughter was coming up to do the legwork for him. Okay. And that is who I met. That's who the phone call came for us to come and help get this person moved, packed and moved. They were moving her into an independent living apartment, which she needed to be into much more care than that. But we often run into families going independent because it's cheap. Okay, cheaper. Okay.
Mm.
And then having the conversation going, maybe you gotta think about this. But
Yeah.
so in any case, the family from out of state were wonderful people. They were coming out of pocket to pay for expenses. They were doing all these things, and they were, really trying to jump through the hoops. And I was able to have conversations with them about, hey, we'll get her here to this place, but then we're going to start thinking about this, and I want to get you with an attorney to look into Medicaid waiver because they were paying out of their pocket. And I go, you don't need to be doing that. And in the process, this client's best friend, okay, who she had known for 2 years when her caregiver, who I really don't, after seeing the person's house, her house, I have no idea what this caregiver was doing. She sure wasn't a housekeeper, and she wasn't a caregiver. She was just hanging out there. But she had taken her to this jewelry store to sell some of her jewelry for cash, and the woman working there became her best friend, and it was now on her will. Okay, after 2 years.
Mm-hmm.
So, I would look at both the caregiver and I would look at this best friend, and I would put them on a scale of between enablers and predators, and I would lean towards the far side. Okay. And we were trying to do what we could to get this done. And then what happened when we were in the process of doing about halfway through, the best friend threw a fit, called, got the client all worked up, who then called her attorney, who switched the POA from the cousins to this best friend. Okay. And when I called the attorney to talk to her about it, she was from a very, very prestigious firm. Okay. But I called, I'm not going to say who, but I called to say, have you been to this house and all the animal waste and the hoarder situation this woman was living in? And she goes, well, her comment was, we found out she has no money, so we've dropped her as a client. And I'm going, but you put her in this situation. So we're trying to, I mean, none of this is our business, right? We're just supposed to pack you and move you and help you sell off your extra stuff. But we were trying to get her into a safe spot. That was kind of where it was. And I was trying, and then when they fired the cousin from doing the POA and stuff, I really didn't know how to do it. But I was like, finally, when the best friend, new POA, found out there was no money, she was trying to figure out how to get rid of her, and I was
Yeah.
begging her to get with a guardian, someplace to help get this woman in a safe spot. What do you do in circumstances like that?
Honestly, there's not much to do.
Is it?
I mean, there you could, if there was somebody willing to serve as guardian, you could go get a guardianship if the cousin was still willing to be involved. But there's no, yeah, Indiana has no public guardianship system. The closest they have is care. But again, they only take clients that come from certain hospital
Yeah.
systems. And so, yeah, it's hard, next to impossible sometimes for um, those kinds of individuals to get help. It's really sad.
Yeah, because I mean, unfortunately, that she was probably one of the most uniquely horrible cases. But you do run into situations that are not that far off. So.
Oh yeah, I we've seen it all for
Mhm.
sure. Yeah, lots of hoarding situations. Um, you know, Lots of houses that shouldn't be lived in by humans. Yeah, it's sad.
Yeah.
Yeah.
Well, that's one of the questions because I'm like, it's like I basically had this, adjust to myself saying, turning into child or to senior protection services. I didn't know at what point that would do because they'd already stolen everything. There was no assets. There was none. There was nothing. So they really couldn't do any more damage that way. And they weren't doing physical damage. So it's kind of like, well, here we are.
Yeah, and Adult Protective Services has gone through a lot of changes and you know, I'm not sure how much of a resource it is anymore in any circumstance, unfortunately. So yeah, it's really hard. It's really
Okay.
hard.
Well, like I
Yeah.
said, I'm just kind of looking because I'm sure this will come up again. So
Yeah. If she needed like nursing home level of care or even assisted living where you could get her in a facility and the facility would apply for Medicaid benefits and she could stay there, at least maybe she'd be safe. Um, that happens a lot. The
yeah.
facility will, file Medicaid and keep them there. It's not the best option, but sometimes it's the only option.
So what do people do um, if they're thinking about this? How do they call
Mhm.
you or you or someone in your type situation and
Yeah.
find out how do they go through that process of trying to figure out if it's a good fit?
Yeah, absolutely call us. Even if we're not a good fit or we can't take the case, we do try to provide resources. All our consultations and things like that are free. Jane Malkoff, the nurse practitioner that co-owns the company, takes all those calls. Her phone rings all day, every day. So yeah, we'll absolutely help. We'll refer to a trusted attorneys if we can't handle it. We'll do the best we can to provide resources if we ourselves can't manage it. But yeah, we never hurts to call us.
All right. Well, thank you very much. I mean, this is an area of care that I think a lot of people don't really understand. And that's why I thought I'd love to get a chance to have you come in and talk about it and what it is
Sure.
and what it's not. And, then kind of, but there's a lot of people that have this need. I mean, there's a lot of people that don't have family. They're by themselves. But they need to have that advocate. And, I'm a, Jane, the nurse advocate, geriatric care manager, whatever they want to. They all call themselves. That's one problem in that industry. They all call themselves by different
Just because
names.
it's really not an industry. It's
Yeah,
just anybody can call themselves a care manager.
right. But it's really kind of confusing. We
Yeah.
have used one in our family for 10 years now. I think it is. When I was managing care for my mom and for my uncle, my siblings both live 1,000 miles away, and so it's kind of like you know, once we found this, I was like, it was the most amazing thing in my life because they basically played quarterback,
Yeah.
to keep all this stuff going. I didn't have to have, I don't know how I would have continued to work with
Right.
that. And then that particular caregiver that we had for both of them, um, she burned herself out. Okay, and then she had to step down and she had some illness. And so, uh, but thankfully, in the process, what I do for a living, I work with senior care people all day, every day. So I had a whole list of people, like Jane, that do those things.
Yeah.
People that don't use that service have no idea how much they need that service.
Yeah. For
You know,
sure.
so
For sure.
but it is a huge asset to have someone there. And I have learned by having this that when you're at the doctor or when you're at the hospital or the rehab or whatever it is you're doing, and if you get to a certain age, then that all becomes part of the rotation. But anyway, um, the doctors and the nurses will talk to them differently than they talk to you. They will tell them things they don't tell you.
Mm,
Um, so I get more information. We get more information. We get more. I think we get more care because they have that. They kind of perk up that this person's also a trained medical person, and they treat the situation different,
I think that's absolutely true. Yes.
which
Yeah.
is unfortunate. Other people are not getting that. So but
Yeah,
so
for
well,
sure.
thank you so much for coming. What would be the one last thing you want people to think about when it comes to what you do and why they need to talk to you guys?
I would just say be really thoughtful about who you're naming in your estate plan. I think a lot of people don't know that there's an option like us. We have 178 people on our inactive roster, meaning they have named us in one role or another, and they sit on that roster until they need us. And we, like I said, we have this check-in process where one of our nurses calls every so often, checks in, hey, how's it going? How you doing? They're trained to, you know, suss out any differences or concerns and report back. And, through those check ins, we have learned several times that our clients are in need of help and they didn't even really know it. So once you're on our roster, you're a client and we will take care of you.
Okay, I'm going to have you flesh that out more. What gets somebody on the roster?
Yeah, so they name us in their estate planning documents. So either as a power of attorney, healthcare representative, those are the two main ones where we're checking in, seeing if you need us. We also serve as personal representative, trustee, but those aren't as urgent as a power of attorney and healthcare representative. So most of the people on our roster, they'll name their spouse first, but then after their spouse is us. And so then we're checking in or, calling up. There is like a fee to stay on it's pretty low. Right now, I think it's $250 to get like on that roster. And then we just charge a little bit for those check-ins every year, every other year, every couple of years. And that's how we stay in touch with our clients to see if they need us to step in. Or we've had cases where we had a case where a woman who seemingly healthy was living at home, went through an acute medical episode where she was in a coma essentially in the hospital, went through rehab, ended up back home, but You know, we knew she had dogs. We knew what to do with the dogs. We could check in on the house. We could make sure her bills were paid. And then once she got out of the hospital and is back home now, we've kind of backed off. So
So
it's
you're
just
kind of like the program running in the background that nobody knows is there.
correct. Yeah.
Okay.
Yep.
And then till all of a sudden the music comes on because you need it.
Yeah. Yep. Yep. That's right. So we're sort of, yeah, that security that you have a professional in place
You're an
to,
insurance policy.
yeah. Yeah. That's right. Pretty
Okay.
inexpensive one too.
Okay. Well, I mean, but I mean, I was just trying to think how that works, but
Yep.
that because that to me is makes a lot of sense because while you got your cognitive abilities, while you have all the ability to make these decisions, you can make these decisions, and then you kind of just forget about it and go about your life
Right. Yep.
until something triggers
Yep.
that to come forward.
Yeah, we'll call you every now and then. Just make sure you're doing okay. Seeing how your needs are. And then at a certain point you need more help. And then we step in.
Excellent.
Yeah.
Well, thank you so much for sharing with us, Sarah. I really
Sure,
appreciate that.
Jim. Thanks for having me.
All right, have a good one.
You too.
Bye bye.